Yes, Mr. Hart.
We saw this morning the reaction of the Chinese court, observing that by coming to sue in England, Conversant was seeking to avoid judicial review in China of its key Chinese patents. Now, it's not only the Chinese courts that have expressed disquiet at the decisions in this jurisdiction. The German court also, if we go to the decision at A8, tab 137.
Sorry, can I have that number again?
Yes, it's 9, the decision starts at 9310, but the relevant part that I want to go to is 9391, my lord.
Thank you. What was the name of this case?
This is Huawei.
Oh, yes.
And Unwired Planet. It's the same parties as here. What had happened was that Unwired sued Huawei both in England and in Germany, issuing proceedings on the same day, and the German proceedings for German patent infringement continued in parallel to the English action, and continued even after Mr. Justice Burse's judgment was delivered, in which he set royalty rates for Germany as a major market. And an issue arose in Germany about whether the German royalties that Unwired was seeking were discriminatory. And the German court considered that was an issue that it was appropriate for it to determine. You see this at page 9391. And the German court wanted to see the prior licenses that had been entered into by Ericsson. And when told that the English court had already set license rates and held them to be non-discriminatory, the German court's reaction, as you can see about two-thirds of the way down, was equally insignificant are the remarks on what the British infringement court did in determining the FRAND license in foreign parallel proceedings. Since the Senate must convince itself of the freedom for discrimination of the license offers in dispute, the relevant facts must be presented in detail to the Senate, which did not happen, and for which there is no willingness according to the plaintiff's unjudged statement of intent. Consequently, the license offers addressed to the defendants do not show in the appropriate manner the license fees and the way in which they are calculated, thus maintaining the privilege of the defendants to owe no more than the FRAND license fee for the use of the plaintiff's patent. But the important point about this is, not really surprisingly, the German court considers it's a matter for it to determine what are appropriate royalty rates for a German patent. The issue of non-discrimination was for it, but if one follows through the consequences of this, we are facing a situation where the courts in this country determine that, and on their approach, we'll come to that on the issue, that the license, the royalties were appropriate and not discriminatory. Whereas the German court might say, well, actually, we do regard them as discriminatory and set a different term. But Huawei would be injuncted in this country for refusing to pay the rates set by the English court, even though the German court, in respect of the German patent, thought they were inappropriate. And in our submission, this just illustrates the difficulties that one is getting into when a court which, on our facts, is actually only concerned with 1% of the sales, is purporting to determine rates for the whole world. Now then, I'd also like to just look at the approach to these issues in some other jurisdictions. Can I take you to the Apple and Motorola case at A4 tab 81, and the MS number of the start of the judgment is 6572, and this is a decision of the US Court of Appeals for the Federal District. It's the specialist US Federal Court. And if you go to page 6617, Judge Rayner is dealing here, as you see on the left-hand column, it starts with Motorola's request for an injunction, and in the second column, first complete paragraph, refers to the 898 patent, a particular patent, which is a SEP, and thus Motorola has agreed to license it on FRAND terms, and then refers to the district court, which had said, I don't see how, given FRAND, I would be justified in enjoining Apple from infringing the 898 unless Apple refuses to pay a royalty that meets the FRAND requirement by committing to license. Motorola committed to license to anyone willing to pay a FRAND royalty. And then at the bottom of the page, they said that to the extent that the court applied a per se rule that injunctions are unavailable if erred, while Motorola's FRAND commitments are certainly criteria relevant to its entitlement to an injunction, we see no reason to create a separate rule or analytical approach for framework for addressing injunctions for FRAND committed patents. And then they refer to the eBay case, and then say that a patentee subject to FRAND commitments may have difficulty in establishing irreparable harm. On the other hand, an injunction may be justified where an infringer unilaterally refuses a FRAND royalty or unreasonably delays negotiation. And then a bit further on, they explain that the public, the paragraph sentence beginning in addition, the public has an interest in encouraging participation in standard-setting organisations, but also in ensuring that SEPs are not overvalued. And just stopping there for a moment, that public policy is an important public policy for all jurisdictions. And it's obviously in this jurisdiction important that SEPs are not overvalued, because if they are, that potentially affects UK consumers. But of course, if Chinese royalties are held due on sales in China, as has happened here, where in fact nothing is due, it will be the Chinese consumer that will be affected. But what is clear is that the approach of the US court, and I won't read it all out, but commend you to judgment, the court was approaching it on the basis that a US royalty was sufficient the US court would deal with, and that was sufficient for FRAND purposes. And at 6628, Judge Posner the passage in the right-hand column, that in the second sentence, and as Apple points out, an alleged infringer is fully entitled to challenge the validity of a FRAND committed patent. And then it's explains, second, there are many reasons an alleged infringer might prefer to pay a FRAND license rather than undergoing extensive litigation. And in our submission, that's an important point, and why you can't extract from the fact that very often parties enter into, by consent, agreements for disputed global portfolios, that all that you extract from that is that reasonable commercial men very often don't want to litigate. That doesn't tell you anything about what the approach should be where parties do litigate.
I may be mistaken because I haven't looked at this case until we were taken to it just now.
Yes.
But I think this may be a dissent on this part. On this
It is
point,
a dissent.
isn't it?
I'm sorry, I should have pointed that out. It's only a dissent in part.
Yes, but I think this is a dissent. This is a dissenting part. I think he begins by saying, "I disagree." That paragraph. I disagree that an alleged infringer's refusal to enter into a licensing agreement justifies entering an injunction. But majority decision, I think, was that refusal to enter into a FRAND agreement did justify an injunction.
But I think the majority, there wasn't any disagreement that where there was a dispute about the validity, that had to be determined. And you'll see that in two other references I would like to take you to. The first is a case called Optus Wireless. Optus is the owner of Unwired Planet, and it's a case at A6. And it's at tab 117, and that's MS 8318, and in this case, Panoptis asked the District Court of California for a declaration that it had complied with its FRAND obligations, both under US and foreign patents. And Huawei asked for the court to dismiss the foreign part of the claim. And if you go to page 8331, you see under the heading, the first paragraph, Panoptis' argument was that it had complied with its obligations by offering a worldwide license. Huawei points out that the declaratory judgment implicates foreign patents and foreign FRAND law. Huawei asked the court to dismiss the foreign part of the case, and the argument at 8333 that Panoptis put forward is the argument here. Panoptis' arguments are less about what the law is and more about fairness. One argument is that foreign courts are increasingly making global FRAND determinations, and it would be unfair if the US courts didn't follow that trend, or it would not be unfair to require Panoptis, or it would be unfair to require Panoptis to litigate FRAND disputes all over the world. But at least some of the foreign courts Panoptis called attention to are not courts of limited jurisdiction. The net result is the court's view was it couldn't entertain the foreign claims. And Panoptis itself, if you go to A11 at tab 212, has correctly summarized the position. MS 12018 in a case where it is the party against whom a FRAND license on a global basis is sought. And this is their brief to the court. And you see it, if you go to 12052, line 17, refer to the fact that they say Continental cannot overcome the fact the court doesn't have jurisdiction to dictate terms and conditions of a license where many of the patents at issue are granted by foreign jurisdictions. And amongst the authorities referred to is the well-known Voda case, holding that adjudication of foreign patents infringement claims should be left to sovereigns that created the property rights in the first instance. And our submission, their submission there is entirely right, that the approach of a national court should be to concern itself with the national patents for it and with setting royalty rates for matters properly within its jurisdiction. And certainly in terms of injunctive relief, shouldn't be giving an injunction which is seeking to support foreign rights. And can I just pick up a sort of an important point about this? You've seen the license agreement that Mr. Justice Burr settled, and you've also you've seen that, and you've seen the judgment of the Nanking Court. The important point to understand when one talks about a global license, it is in fact simply an aggregation, a collection of licenses for the different countries. So this isn't a situation where anybody is saying, well, the terms on which, for instance, let's say you have if we're looking at a single patent, say you have a patent which is for the 4G standard, and you have related or family members across the world. The approach to this isn't to say, well, what you have is a rate which covers the world for that. What you have is rates which are per country, which in other words are for the patents in each country. And the only advantage of the global rate is that you get there may be for the implementer a discount in that it's more administratively efficient and more administratively efficient in this sense. In these cases, what you're talking about is monitoring Huawei's sales. But the fact, in our submission, it's a slight misnomer when one looks at this as a global license. It's a license in respect of all different countries at differing rates, or at least differing rates on Mr. Justice Burt's approach to China and the major markets. So the position in the United States, if, for instance, Unwired Planet sues Apple in the United States court will confine itself to looking at the patents in the United States and will not seek to determine a FRAND rate for the United Kingdom or China or wherever. Now, the position in Japan is effectively the same as the United States. I won't take you to the authority, but we've referenced it at paragraph 98 of our reply, which is MS 10417. Now, as you know, there have then been there's some European authority. So there's the European Commission decision in Motorola, which in our submission is entirely consistent with Huawei's position. Lordships see that at A6, tab 115, page 8177. And the course, the European decisions, the decision of the Commission, and then I'm going to go to Huawei and ZTE, of course, they're not concerned with construing, as we are, the ETSI undertaking. They're concerned with the European question of potentially anti-competitive behaviour. But the issue was whether Motorola had infringed Article 102 by seeking and enforcing a German injunction against Apple in Germany. Motorola demanded a global license, and Apple only offered a license covering Germany. And the Commission held that Apple had the right to expect a German-only license. And if you go to page 8190, starts the relevant passage. Obviously, I don't want to waste time reading things out. If you go to page 8189, it's the start, beginning, background. At paragraph 42 on 8191, the Commission, having referred to the EU IP Enforcement Directive, explains that damages as substitute for an injunction may be awarded. And they then have a section at 8192, which is on standards, standard setting and sets. 8193, they explain SEPs, paragraphs 52 and 53. And they explain the point about market power, which is actually an important point to understand when one considers how the ETSI undertaking works and injunctions that the court should give. The whole purpose of the standard and of ETSI is that the patent owner who has a standard essential patent shouldn't be entitled to shouldn't be entitled to exercise power by injunction, and this is what explains that what he's entitled to is a royalty. Then they explain at 8194 the ETSI IPR policy. You see at paragraph 61 that ETSI doesn't check the validity of declared patents. Then we can go forward. Refer to the license offer.
I wonder if you could give us the page number.
I beg your pardon, it's 8261. I apologise. And at 8261, paragraph 440, they explain that Apple had indicated a willingness to enter into license agreement on brand terms in Germany. Apple's reluctance to agree to licensing terms that would de facto hinder its ability to challenge the validity of those SEPs and their infringement by the iPhone 4S don't call into question its willingness to enter into a license on brand terms. And so the effect was that the Commission found it was reasonable for Apple to take the position that it was willing to take a local national license and also to dispute validity. And 488, you'll see the Motorola, page 8268, Motorola at 488, advancing the argument on efficiency of portfolio-based licensing. And you can see the efficiencies in the first bullet point are avoiding patent-by-patent licensing negotiations and avoiding patent-by-patent litigation. And at 489, the Commission said that can't be accepted. And at 490, the Court said, regarding the alleged efficiencies associated with patent-by-patent licensing, Apple already proposed that license would cover the entire portfolio in Germany. It was therefore not necessary for those achievement of those alleged efficiency gains for Motorola to continue to seek and enforce an injunction against Apple in Germany on the basis of avoiding, regarding the alleged efficiencies associated with avoiding patent-by-patent litigation, it is in the public interest to allow challenges to the validity of patents and to ensure that royalties are not unduly paid. It wasn't necessary for the achievement of those efficiency gains for Motorola to seek and enforce an injunction in Germany on the basis of, effectively, is the other step. So in our submission, that is entirely consistent with what we say is the right approach. However you approach it, whether you approach it through how ETSI is supposed to work or through how national courts should respond to these matters.
Now you'll know that the Court of Appeal referred to this, but also to a more recent communication.
My Lord, I'm absolutely aware of that, and I'm going to show why that doesn't undermine what I'm saying. But and the 519 also dealt with Motorola's claim that damage actions don't adequately protect its commercial interest, as such actions are slow, expensive, and generally only retrospective, and so on. Regarding the need to conduct damages action on a patent-by-patent basis as a matter of patent law, injunction proceedings also have to be conducted on a patent-by-patent basis. As to the allegedly slow, costly, and retrospective nature of actions, the fact that Motorola is seeking damages and rendering of accounts from Apple in Germany shows that Motorola nevertheless considers that such actions do provide it with a certain level of protection. Following paragraphs, and also paragraph 540. Now, the courts below, Mr. Justice Burse accepted that in paragraph 552 of his judgment, accepted that the Motorola decision was firmly in Hawaii's favour, but he said in the same paragraph that the decision was premised on the view that a license limited to Germany is FRAND, and he said that was inconsistent with his view that there could only ever be one set of FRAND terms. Now, the Court of Appeal didn't agree with Mr. Justice Burse there could only be one set of FRAND terms, but they regarded the Motorola decision as simply based on a view that a license limited to Germany was FRAND, and they said it didn't apply where a global license was FRAND, and they thought that the Commission had modified its view. Now, the problem with that is it doesn't engage with the Commission's view that it was reasonable for Apple to refuse a global license, which would impair its ability to dispute patent validity and to want a license for Germany instead. What you certainly get from that is that the Commission did not regard it as madness or unreasonable for a party to be doing that. Now, before we come to the further paper from the Commission that my Lord Reid was pointing out. The other authority is Huawei and ZTE, which is a decision of the Court of Justice. That's at tab 106 in the same bundle, MS 7858. And this post-dated the Commission decision in Motorola, and there's nothing in this case to suggest that the court was in any way disagreeing with anything in that. The court specifically acknowledged, if you go to page 7894, at paragraph 69, lastly, having regard first to the fact a standardization body, such as that which developed the standard at issue, doesn't check whether patents are valid or not, which are included. And secondly, the right of effective judicial protection, an alleged infringer cannot be criticised either for challenging, in parallel to the negotiations relating to the grant of licenses, the validity of those patents and or the essential nature of the patents to the standard in which they're included, and or their actual use, or for reserving the right to do so in the future. And this case was actually, you see all the discussion, if you go back to page 7893 at paragraph 59, 60, 61, 63, 64, 66, was, in fact, appears to be in the context of a single patent negotiation. What they're not talking about, and is negotiations in relation to portfolios. Still less are they talking about a situation where a FRAND obligation or FRAND obligation is satisfied by offering a license which includes disputed foreign patents, and a situation where the implementer is required to take a license on those terms. In fact, it's a decision which is limited to Article 102, whether a SEP owner abuses a dominant position by seeking an injunction. So in our submission, it would be odd to say that this was intended to mandate global portfolio licensing and to require that implementers must take licenses of disputed patents. And if you look at paragraph 65, which is the sort of high watermark on which the argument is based, where they say, by contrast, it's for the alleged infringer diligently to respond to that offer in accordance with recognised commercial practices in the field and in good faith, a point which must be established on the basis of objective factors, which implies in particular there are no delaying tactics. None of this in our submission is intended to in any way, firstly, to undermine the right to dispute validity of either the patent which is the subject of specific litigation or other patents in respect of which the patent owner says he is entitled to payment. And that's actually what the critical point about the ETSI undertaking in our submission. There's nothing in the ETSI undertaking to suggest that the purpose of this is to allow an alleged patent owner to extract payment in respect of alleged rights which are disputed and which he's seeking to avoid actually having determined. Now, the commission paper that Lord Reid was referring to is at A8. Tab 148, MS 9539. And the paper is expressly not intended to represent a statement of law. You see that from page 9542. It's intended to be a paper which is intended to create a dialogue. So if you look at 9542, this communication draws on the responsibility of all actors in the SEP licensing context, and all stakeholders are encouraged to contribute to making this work in practice. It is not intended to represent a statement of the law. Without prejudice to the interpretation of EU law by the court, it doesn't bind the Commission, and so on. So it's a call for dialogue. At page 9550, top of page 11,
Sorry,
9550.
Thank you.
Sorry, 9550, and you see at the top of the page, in this context, SEP holders may offer more patents, including non-SEPs, but cannot require a licensee to accept a license for these other patents as well. Now, just stopping there for a moment, that is entirely consistent with saying if you can't require a licensee to accept a license for things which are not in fact SEPs. The general non-willingness or non-acceptance to offer or accept all SEPs that a licensee needs may be an indication of bad faith. In order to be FRAND, the counter offer needs to be related to all SEPs that a licensee needs and cannot be based on individual patents only. Portfolios, however, should not include competing technologies and so on. Now,
Is the reference to including non-SEPs to be taken to mean those which haven't been proved to be SEPs or those which haven't been declared to be SEPs? I mean, it could just mean you're not allowed to bundle in patents that you're not even suggesting are SEPs.
I think it is essentially dealing with what your Lordship has just said, which is you can't add in something which is not a SEP. But it isn't saying equally that it's okay to bundle in declared SEPs. Because at the end of the day, a declared SEP, which is in fact not a SEP, is not actually a SEP. For instance, a SEP which turns out to be a valid patent but not essential is a non-SEP. It's a patent, but it's not a SEP. A patent that isn't valid is just nothing.
I can understand that's literally true, but if I was an operator or a what's the word, utilizer,
Yeah.
and I wanted a compliance with a FRAND undertaking because I wanted to sell and manufacture across a range, I'd be quite surprised if the patentee asserted that he was making me a FRAND offer which excluded an offer to license patents which the patentee actually were claiming to be SEPs.
Your Lordship's entirely right, and that's if one needs to look at it in that way.
Implementer was the word I meant.
Yeah, no, I agree. If one isn't constantly practicing in this field, and your Lordship knows I don't, then these terminologies are sometimes confusing. But implementer. So the implementer may come along and say, I see that you have declared a 1,000 SEPs, or whatever it is, all over the world. Now, a perfectly rational position for the implementer is to say, I don't know whether they are in fact valid or not, but you having declared them, I want to enter into a license. Now, the patent owner couldn't refuse because the patent owner's position is that they are in fact SEPs.
Yes.
But we are in a different situation where the patent owner has self-certified, and he is saying to somebody who is doing something in the UK, I want you to enter into a license not only for the UK, but for China, where the implementer says, but I don't think you have any rights in China. And in our submission, in that situation, there's nothing which, where he's not entitled to require that when he can't establish what his rights are in China. And this, insofar as one extracts anything from this, the view, if you extract a view of the Commission that you should be able to do that, it's in fact simply based upon the decision of Mr. Justice Burse. And you get that if you go back to page 9548, where
I think 9546,
yes, it's
footnote 33 cites Mr.
yeah,
Justice
sorry,
Burse.
it's at, yeah. I mean, insofar that they cross-refer to Mr. Justice Burst's decision on 9546 under efficiency and non-discrimination. And the last sentence under 2.2, as noticed in a recent ruling, a country-by-country licensing approach may not be efficient and may not be in line with a recognised commercial practice in the sector. That's essentially just reciting what Mr. Justice Burse said. In our submission, it doesn't take the matter any further forward. Now, the only jurisdiction where one does find the courts granting injunctions, not on the same basis as has been done here, but on a basis where they have looked at global offers, is Germany. But the German position needs to be approached with caution because their position is coloured by the bifurcated procedure with separate infringement and validity courts. And it is a frequent practice in Germany for courts to rule on infringement ahead of validity, and so grant injunctions on an assumption of validity. In effect, what the courts in Germany are doing is granting what we would regard more as an interim injunction, because they do it on a basis where the patent owner has to put up a bond as security in case the patent is later invalidated. Something we do at an interlocutory basis, but not in respect of final injunctions where rights have been determined. Now, it is fair to say that the German courts have, in some of the cases, regarded global licenses as friend, but as so far as we are aware, we do not understand there has been any case in which the implementer has disputed the validity of the foreign patents to be included in the license, and so raised the sort of jurisdictional objection that we have raised. Now, I go through those cases to come to this point. The theme of Mr. Justice Burse, or a theme in a very, very lengthy judgment, is in relation to this issue, that the madness point, that it's madness to have licensing on a country-by-country basis. And it is perhaps worth just turning up the paragraph where he makes that point, which is MS page 748. And he introduces his madness point. By saying, before turning to the impact of the litigation. And in our submission, that is actually a core or a point at which the analysis is going wrong. The fact that outside of litigation, parties, willing licensors and willing licensees might agree to portfolio licenses, but doesn't tell you, or doesn't inform you where there is a dispute. And indeed, no one suggests that invariably people accept validity of patents. Indeed, it's common ground that validity in patent disputes is very often an issue, not least because of the statistics which show that if you dispute validity, you're more than likely to be right. The strike rate is very low. So the point is this: in the real world, people disagree, and when they do, they return to the court to resolve their rights and obligations. And in our submission, the subject matter of the dispute takes focus in the claims in the court which define the subject matter of the hypothetical bargain, for the striking of which the court can call on fictional creatures such as willing licensors and willing licensees. And in our submission, the Court of Appeal fell at paragraph 128 into a similar error. And Apple put the fallacy well in their written submissions at paragraph 10, which is in the supplemental bundle tab 4, MS 10463. That the essential fallacy in the reasoning of the Court of Appeal, affirming Mr. Justice Burse, is the leap from the assumption that a willing licensor and a willing licensee might agree a global FRAND license to the finding that it is legitimate to enjoin infringement of a UK patent unless the prospective licensee enters into a global FRAND license on terms determined by the English court. Now, as I have said, Mr. Justice Burse avoided the error when he came to consider damages. And you see that at paragraph 800 of the judgment, where
Can we have a page number?
Oh, sorry, 794.
Thank you very much.
So you see the section on damages, and 797 makes the point that damages are compensatory. 798 refers to the General Tyre case, and the measure of damages, it quotes from it, must pay will be the sums which he would have paid by way of royalty if instead of acting illegally he'd acted legally. So for a SEP owner, this means a FRAND royalty for the patents in suit. And he then, you then see that Unwired's argument at 799 was the correct royalty rate to use to assess damages was a per patent rate, because the damages are infringement of a particular patent, shouldn't be affected by discounts available in FRAND licenses. And he said that submission was wrong in principle as a matter of ordinary patent law, regardless of whether, as Huawei contended, it leads to non-FRAND damages. Then at 800, 801, he determines essentially a portfolio license of the UK patents, but on so the damages at 801 he explains why he's doing it on that basis, but his approach, the important thing is, his approach here is that the damage that Unwired Planet for the past is adequately compensated for the infringement that has taken place by being paid for its UK patents. And it's not, and no one was suggesting, Unwired themselves weren't suggesting, that they're entitled to be compensated on the basis that for the UK patents they would have been entitled to require a global license, and therefore the damage should be what they should recover on the global license. And so this results in the mismatch between the damages and the price that the English court seeks to extract. In our submission, a FRAND license demand is a demand for payment in respect of the patents subject to the license. Now, there is absolutely nothing to stop, if you look at it from the patent owner's point of view, there's nothing to stop him offering a global license, and that may be of all the patents. But the simple point is this, the issue doesn't stop there. Where the implementer says, I don't agree that you have anything other than the UK rights, and disputes the validity of the foreign patents, then the focus turns to the claims presenting in court. In our submission, the courts below have lost sight of the transition from commercial negotiation to dispute resolution in court. Once the implementer disputes the validity of foreign patents, then effectively, as one sees in the United States court, the foreign patents are off limits for the national court. And the FRAND royalty, which the national court should be considering, just as you see in the United States, Japan, is the, and indeed in the United States and Japan, is the FRAND royalty that has to be paid to resist the injunction is a royalty for the infringed patents.
Can I see if there's an implication in that? You say the patentee is perfectly entitled to propose a global license.
Yes.
But if the implementer says, well, actually, I'm disputing your foreign patents, then we're into a new ballpark and we're just looking at national patents. Does it follow, therefore, that you impliedly accept that the offer of a global license could, in those circumstances, be FRAND, but nonetheless, unless another offer of a UK, in this case, only license is made, he can't get an injunction?
In my submission, the offer, the court is not able to assess where you put the foreign patents in dispute, that it is FRAND, because the court is not able to assess the validity of the foreign patents. It's because this is actually what you see has happened in the Unwired Planet case. The court isn't saying the foreign patents are valid, but it's saying you must pay for them, but you'll cease to pay for the major markets one if you knock them down to a certain level. Now, let's assume you had some similar mechanic all across the world. So while you knock ones out, you don't pay. And even if you had a mechanic which said, well, we'll require security to be put up, you would still be requiring, as a term of an injunction, something to be done which potentially was not in fact FRAND. It's simply you don't know is what it amounts to. And that's why the non-justiciability infects all of this. That's what, so what is it that infects the United States approach? It's because the United States recognizes, the courts there recognize they are not a competent court to decide whether foreign patents are valid. Therefore, it's not competent for the court to try and assess a FRAND rate for patents which are not before it. So that's my first point. And my second point is, if you get to a situation where you say, I noticed the court's reaction when I showed you Mr. Justice Burse's settled global license was, well, that's the terms he set, but essentially the subtext was, well, can't this all be dealt with by mechanics? And in the conversant case, interestingly, the court there, both Mr. Justice Carr and the Court of Appeal, seemed to assume you could have some mechanics. But in my submission, that would, even if you could do that, and I say jurisdictionally you can't, but even if you can, that then actually begs the question, what on earth is the English court doing? Because if the English court is saying, well, this is just a provisional FRAND rate, and security should be put up in case that's wrong, one wonders what on earth the point is, why the English court would be doing it. One would also need in that situation for the English court to be giving way not only to questions of validity and essentiality, but also to what is the appropriate rate. I haven't spent time explaining to you, but not all courts necessarily approach matters in the same way in assessing the value of patents. There are a number of ways you can do it. So, for instance, you can have what's called the top-down method. The vice in the top-down method is that it ascribes an equal value to any set. It's just, one might say it's rather crude. It's just a counting system. Another way of doing it is the approach, but that's the approach that China has adopted. Another approach is the comparable license approach, which Mr. Justice Burse put forward as his main approach, albeit he cross-checked by reference to top-down. But another approach in other courts is to say, well, actually what you should be doing is seeing what value this particular set has. Because in the real world, of course, not all sets are equal. Some may be keystone, as it were, and others may be relatively trivial, and others may actually be ones which, in reality, an implementer doesn't even use. It doesn't follow that something is a set, because some of the sets relate to what may be an optional part. So there are complicated issues about how you go about things. And in our submission, these are matters which are peculiarly for each domestic court and part of the dispute to resolve both as to validity, essentiality, and what is the value of the monopoly right in that jurisdiction. And there are also public policy issues. Now, can I then...
But before we move on, can I just ask you, the undertaking given to ETSI to issue FRAND licenses, to issue a FRAND license, applies to declared SEPs.
Sorry, could I just get it out? Sorry.
One finds it, let's see, the declaration is on MS 668 in Mr. Justice Burse's judgment. One has, it's perhaps helpful to look first of all at the quotation in paragraph 130, that the declarant hereby informs ETSI that the but it's its present belief that the IPR as disclosed in the attached IPR information statement annex may or may become essential in relation to the standards identified. And then the licensing declaration is in accordance with clause 6.1. The declarant irrevocably declares, to the extent that the IPRs disclosed in the attached statement are or become and remain essential standard, the declarant and or its affiliates are prepared to grant irrevocable licenses on terms and conditions in accordance with clause 6.1. And then 6.1 itself is on page MS 659.
Yes.
Where it says that when an essential IPR relating to a particular standard is brought to the attention of ETSI, the Director General shall request the owner to give an irrevocable undertaking that it's prepared to grant licenses on FRAND terms and conditions. Yep. So the undertaking relates to all the SEPs, or at least claimed SEPs, that have been declared.
The undertaking, in fact, only relates, that's if we could, the undertaking relates to an SEP that is, or becomes, and remains essential. It has to be an essential. Mm-hmm. And so that is not a declared SEP. That is something which actually is essential. That's well. Once you've made it, this picks up the point that Lord Briggs was making to me. The person who is declaring the SEP, if somebody comes along and says, "I want a license for your entire," or it depends how he's done it, because he can declare individual ones or he can do it en masse. But the person who comes along and says, "I would like a license," he can't say, having declared it, that it's not essential, therefore I don't have to license you. And therefore, from the implementer's point of view, if he wants to say, "I want you to provide a license of all of the declared SEPs,"
yes,
he would be taking a license on the basis that they say they are SEPs, and he's not disputing it.
Yes.
But picking up your Lordship's point
yes.
about clause 6.1, 6.1 is the provision that provides when an essential IPR has been brought to the attention, you have to give an irrevocable undertaking. You're prepared to grant irrevocable licenses, and that is in the plural because it means to the world, on FRAND terms. That is, in fact, ETSI operates at the patent level. That's all. In my submission, the contrary is actually unarguable when you look at the way the undertaking operates and what they're talking about. Yeah. That doesn't mean to say, and this is really the next critical point, that does not mean that an implementer can't come along and say, you say you've got 10, I'd like the 10, and equally, when he says I'd like the 10, that there may be, because of the economies of scale, a argument that I'm entitled to a reduced rate because there are 10 rather than 1. But none of this, and there's nothing whatsoever in ETSI which says, supports the position that what is intended to happen, or even anticipated happening, is that a patent owner, because he's got a whole lot of declared sets, is entitled to require, as the terms of using the SEP in one jurisdiction, a license in respect of the ones that are disputed elsewhere.
Yes.
I mean, in our submission, what's more, that we've said this in our written case, and in my submission, this is entirely right. It turns this on its head.
Yes. So you would say that the declaration on page 668 is confined to IPRs which are actually essential which are actually essential. Yeah.
You could have had a system, where you say, I mean, it would be rather odd, bearing in mind, this is made against the background of people knowing that patents very often are not valid, and also that Etsy hasn't checked validity, and Etsy hasn't even done anything rigorous to establish whether anything is essential. So it'd be rather odd if the effect of this system is that getting one SEP is, as it were, the golden ticket to say I can be paid for a whole lot of what actually are not SEPs.
Yes. And then when one goes to 6.1, an undertaking that is prepared to grant irrevocable licenses, well, licenses of what? You would say licenses of what is actually an essential IPR.
Exactly.
Yeah. Now, there wouldn't have to be, in terms of those declarations, they wouldn't necessarily be confined to, for example, a UK patent, so far as a UK court was concerned. The obligation would be to grant a license of whatever IPRs were in fact essential.
The obligation, as your Lordship says entirely rightly, is to grant a license of whichever ones are essential. But you then have to ask, self-evidently, where the patent owner says, well, I've got a patent in the UK, a patent in Germany, and a patent in the USA and China, comes to the one court, but he can only, before that national court, bring forward the injunction, the one there, which justifies an injunction in that court. Does Etsy say he's entitled to say, well, the English court said this one's okay, let's not look at any of the others.
That comes to the question of what terms and conditions attaches to. If it is terms and conditions for the license of this valid SEP, then that confines it. What the alternative argument is that you can propose, I'm not prepared to let you have this one unless you take the job lot.
Well, but the job...
And that would be the terms and conditions on which I will let you have this one.
But, my lady, surely the job lot only works if the job lot consists of other essential IPRs.
Yes. Well, you could read this in a number of ways. You could read this as terms and conditions relating to the royalty, etc., for this valid SEP.
What I'm saying, I'm not disagreeing with you, that if what you say, the first question, I'm not disagreeing. If you come along and say, look, we've got a judgment in China which says I've got 10 there. You're using one in the United Kingdom. I'm coming to England to get an injunction, and I'm saying to the English court, look, there's a binding judgment here. This proves I've got those 10 in China. Give me an injunction. Now, that raises a question as to whether that is an appropriate use of an English injunction to support a foreign patent which has been established. But we're not in that situation. So we're in the situation where the job lot is, who knows whether or not what is sought to be added in.
Yes. Well, all I'm trying to do is confine the focus at the moment to the actual terms of 6.1 to find out what they really mean and how narrowly terms and conditions is confined, whether it relates just to that SEP.
In my submission, the terms and conditions under such IPR are the terms and conditions relating to the essential patent.
And you would say that because the undertaking is confined to patents which are actually essential, an English court can only determine whether a patent is essential if either it's an English patent or, in the case of a foreign patent, its validity has been established by the relevant foreign court.
Yes, that's right. I mean, as I say, there would be a separate question, even if validity is established by the foreign court, as to whether it's an appropriate use of this court's injunctive power to enforce what is a foreign right. But we don't, in our submission, you don't, when we're just at Etsy, the English court, in my submission, is confined because another way of looking at it is not dissimilar to the judgment on prorogation, where I think what was said was that the piece of paper, the document requiring prorogation was just a piece of paper. Well, we would suggest that the foreign patent is just that. It's just a piece of paper in the eyes of the English court.
I suppose the issue raised by the question put to you by Her Ladyship might be put this way, that if the undertaking is confined to essential patents, can what amounts to the licensing of patents not shown to be essential be achieved under the heading of terms and conditions?
In my submission, no, it can't. And everyone who's looked at this says you can't bundle in non-SEPs. And so once something is not an essential patent, that's what it is. It's either a non-right at all, or it's a patent which isn't a SEP. One of the things you have to remember is fair, reasonable, and non-discriminatory also means these are available to the world. Essentially, what this is really intended to do is that you have, in common parlance, a price list which is available for people to. That's how it really should work, and you can select and pay for things under. You either take one or you take 10, and there may be a different price for 10. What you can't be forced to take is things that you don't accept exist and the court hasn't determined exist.
But another way of putting it might be to say that the only licenses which the undertaking is concerned with is licenses of what are in fact essential SEPs.
Yes. That's actually that is ultimately the point.
But you're going a bit wider than that, because I think you're saying that if an implementer says, well, I don't know if, say there are 10 patents declared as SEP, and the implementer says, well, I don't know if any of them are SEP, but I want a license for all of them, then the undertaking, you say, would extend to all of them, because the patentee isn't entitled to deny that they're SEP, having declared them as such. So it's not actually whether they are truly SEP or not that governs what the FRAND license is, as I understand it, but essentially what the implementer asks for.
I don't think it's the undertaking is just in respect of essential SEPs. That's clear on the face of 6.1.
Well, except that I think you did say in response to my question that if an implementer asks for all 10, but saying effectively, I don't know if they're valid or not, then the licensee couldn't say, well, I'm only going to give you a license of one, and make that a FRAND offer.
Because he is the one who's saying they are essential.
Yeah. So whether they're not essential or not, you say, he's bound by his assertion that they are.
He can't stopped in English terms.
Exactly. He can't come along and say, you've got to remember, the thing is, the way this all has operated over the last 20 or 30 years is that people put in their patents. There may be some question as to the extent to which they have been accepted or not in setting the standard. But by saying, I declare it, you're saying, my position is they are essential. And as my lady says, in English eyes, you'd say, well, having said that, you're bound to treat them as essential. Therefore, I'm entitled to say I want a license. But the converse isn't the case. Because you have self-certified it as essential, you can say, I've got to pay for it.
But it does, doesn't it, then mean that that in terms of what patents a FRAND license covers, within the general category of all declared SEPs, and we're not concerned, I think, with anything outside that category, really it's the implementer who calls the shots. Because he can perfectly well say, I mean, it's most unlikely that all 10 are going to have been litigated about around the world in different countries. He may well say, well, I want 2, or I want 1, or I want 3. In any case, the patentee can't say no, but the patentee can't ask for 4, 5, or 6 without going to the country in question and getting them demonstrated to be valid and essential.
And again, and there's nothing particularly surprising about that.
Well, I'm just slightly surprised because I'm not sure I can see that having been suggested before anywhere in these voluminous papers. I'm not saying it's wrong.
Well, when you say you haven't seen it suggested in
anything I've been preparing, that it ultimately really what is or isn't FRAND in terms of the licenses covered is all to do with what the implementer asks for.
It's the implementer. This all arises in the context of the owner seeking an injunction, obviously, and in this jurisdiction. And the question is, what are the terms of the injunction? And the owner is saying to the court, I want an injunction unless they are prepared to pay me a royalty. Now, we say the natural position under ETSI is that should only be a royalty in respect of essential IPRs. And whereas the other side is saying, no, once I've established one SEP, I'm entitled to claim a royalty for declared SEPs. We say there's nothing that you can get out of ETSI to support that.
Yeah.
Now, when your lordship says, well, does that mean the implementer can choose? The implementer can only choose in the sense that he's entitled to dispute where somebody says, you need a license for this. He's entitled to dispute that this is valid. I mean, if you take the facts of this case, assume Unwired, or like Conversant, assume they come along in China and say, you are breaching Huawei, my Chinese patents, and I require a royalty for the Chinese patents. Huawei is entitled to say in China, no, I'm not. That gives rise to litigation, and the Chinese court will resolve it. Why is the position any different? Because they say, in England, I've proved my English patent, and I want them now. I don't want to sue them in China. I mean, one has got to recognize the reality of what is going on here, and you saw it from that Chinese judgment. The reality is avoiding scrutiny of the Chinese patents in the Chinese court.
Yeah, I mean, we can see the difference between the reference in the undertaking to IPRs, which are or become and remain essential, and on the other hand, the passage quoted in the preceding paragraph, which talks about a belief that IPR may be or may become essential. I was looking at Mr. Justice Burr's page 668 again, contrasting the language in the quotation in paragraph 130 with the language in the declaration in paragraph 131.
Could we look at the ETSI document itself?
Yeah, if I could just
Could
just
you
before we look at it, the point of looking at this was that when you look at the definition of licensed patents in the license which Mr. Justice Burrs thought was appropriate, which is on the relevant passages on MS 819, licensed patents are defined in the wider way. It's anything which is claimed to be essential.
Yeah. And what he is requiring through his approach is payment. I mean, there's no way around this. Mr. Justice Burt's approach requires payment for, by reference to declared patents.
Yeah. So you would be paying, in all likelihood, for patents which were not, in fact, essential, which would go beyond the undertaking that we've looked at.
I mean, and that's that is actually the tension in all of this. When you look at Mr. Justice Burse's judgment, and you look at Mr. Justice Henry Carr, interesting. Mr. Justice Henry Carr recognised it was perfectly proper for my clients to dispute validity in China. Perhaps if you turn to that.
I'm not sure that's an issue.
No, it's not, but it's important to actually understand the difference between the approach that has been taken in Unwired and the approach that has been taken in Conversant. Because if you go to MS 847, Mr. Justice Henry Carr says, paragraph 11, in the circumstances, it is understandable that Huawei China and ZTE China have commenced proceedings in China against Conversant, seeking to establish invalidity and non-infringement of its Chinese patents. Now, just stopping there for a moment. So this patent judge says it's actually perfectly understandable that you do, in the court of competent jurisdiction, seek to dispute validity. What he also goes on to say is that what he recognises, I'll have to find the reference afterwards, is that it's not frowned to require payment for patents which are not valid and essential, which are not essential patents. But this is the tension one's got into. And if one asks oneself, you take Conversant, the Chinese court has now decided that there are, at best, one patent, and it's decided the rate. Now, if in the proceedings in the English court, on what basis could the English court continue to decide that a royalty should be paid on the basis that there's anything more than one Chinese patent?
Well, it could be a royalty on a global portfolio, but where the rate recognised the findings of the Chinese court.
Well, the global portfolio, though, you've got to remember, the rates that they are asking for in Conversant is by reference to a specific Chinese rate.
Yeah.
But the Chinese rate that they're asking for is predicated upon having hundreds or many patents, whether it's hundreds, I don't know. But it doesn't really matter. The Chinese court has now determined that there is only, at best, one. It may turn out there are none. But the only point I'm making is that a FRAND rate for China, in the light of that, could only be by reference to that one single patent. Couldn't have a FRAND rate which you couldn't determine that Huawei should pay a royalty, for instance, for the 14 patents that don't exist. Lordship's looking puzzled.
Well, I'm just not sure that any of that stops a portfolio license being FRAND, providing that the rates may recognise the fact that 9 out of 10 of the declared SEPs in a particular country have been declared to be invalid.
Yes, but you've got to remember, the point I'm obviously not making very clearly, but I'm trying to make is this. It just so happens that the judgment, we now have the benefit of the judgment in China. But the English proceedings could have proceeded whereby the English court was dealing with these matters well in advance of the determination in China. And the English court would then be being asked to set a royalty rate by reference to Chinese patents, which it didn't know whether they existed or not, which ultimately may turn out to be non-existent. And that's the price of an injunction, of a final injunction. In my submission, that's just completely wrong, the idea that you injunct somebody, saying you're injuncted from operating in the UK market unless you pay for these rights, which I'm not in a position to determine, and which I recognise may not actually even exist. Because the consequence would be, what if the defendant says, well, actually, like Zykel, I'm not going to pay for things which may not exist, so I'll just withdraw from the UK market. And it turns out they're right, there are no rights. So you'll have had an English injunction which has deprived somebody of the opportunity to be in the market, which has affected UK consumers, which is on a totally false basis. The reference to the need to take into account China in Mr. Justice Henry Carr is at paragraph 18 on page MS 849. Yeah, I mean, he makes exactly the point which I was just putting. It says, Justice Burst's analysis is simple and, in my view, compelling. Applying it to the present case, there's nothing to prevent Huawei and ZTE continuing in China with challenges to validity. If all the Chinese patents are invalid or not infringed, then any FRAND license will need to provide that no royalties should be payable in respect of them, either for the past or the future. And just stopping there for a moment, that is because they never were payable. It couldn't have been FRAND. That's what the logic of which he's not recognising, because it was requiring payment for something which actually was non-existent. And as he then says, if the defendants are successful on all such patents, then on the figures provided to me, a large part of the royalties would fall away. Interestingly is the last sentence where he says, if the Chinese courts determine a FRAND royalty rate for Chinese patents which are valid and infringed, the English court may well decide to include that. Now, in our submission, that's an odd observation that the English court may well, when you would have thought the court that is appropriate to determine the royalty rate for China was and was only the Chinese court. It's not something one would just simply factor in our submission. And the Court of Appeal at page 577 paragraph 109. They, at the end of that, I mean, they make the point at 109 that ideally decisions in the third line taken with regard to validity and infringement affecting the public in one jurisdiction should be taken by the courts of that jurisdiction. Then they say that's less forceful in FRAND. Then in the last sentence they say, finally, although the English court would be deciding the royalty for China, it would be doing so without precluding the Chinese court deciding validity and essentiality and having that court's decision considered in the context of fixing the royalty, if any, for China. Now, in our submission, the Chinese court it's odd. It's quite right to say the Chinese court is the right court to decide validity and essentiality. What is odd is to simply confine the court's decision on the royalty as something that you'll consider. Now, can I ask you to, in relation to Etsy, could we look at App 9 at starts at page 3595, where you'll find the entirety of Etsy. And I think a lot of what I want to say we've probably covered in the discussion that we have had, but I just want to make sure. So the relevant part starts at 3633, and I'd like to draw attention to the definitions at 3638.
This is the 2019 Etsy.
What it is, your Lordship is right. The way ETSI works is they republish it, but this is the relevant one. They update it all the time, but there's nothing.
Parties agreed this is the one we look to.
Yeah, yeah. In the bundle, just for your note, we have the
1993 ones there as well.
Yeah,
Yes.
and the 1993 one had, because it had, well, I'll come to that in a minute.
I should say the hard copy I'm looking at doesn't have MS numbers on it, but it has page numbers across the middle of the foot of the page.
Okay, I'll use those.
Thank you.
So using that pagination, it's 3165 that I wanted to go to, and the MS page number is 3638.
Okay.
So that's where you have the definition of essential, and it's perfectly clear from the definition of essential that one is dealing with what has to be a valid patent, because essential, as applied to IPR, means it's not possible on technical grounds, etc., to do all these things which comply with the standard without infringing that IPR. You can only infringe a valid patent. I think that rather trite observation has been made by more than one patent judge over the years. You can't infringe something which is a patent. So that's an important point. And the definition of IPR, which is paragraph 7 on 3166, also makes it clear that you're talking about what are actual patent rights. So if they're disputed, then now, at 3649 is the guide that goes with this, and
the other page number?
oh, sorry, 3176. I apologise. And can I say this? What is important when you come to look at ETSI is what it doesn't say. I mean, if it were really the case that what ETSI has in mind is that you can establish one SEP in one jurisdiction, and that is a right then to demand payment for declared SEPs in other jurisdictions, notwithstanding disputes as validity, it would be quite remarkable if you didn't find that spelled out. No doubt my learned friend would tell us where it is spelled out, but I certainly struggle to see that in the guide. And at page 3179 MS 3652, interesting, where they explain the definition of essentiality and say in simpler terms, an essential IPR is an IPR which has been included within a standard and where it would be impossible to implement without making use of this IPR. The only way to avoid the violation of this IPR in respect to the implementation of the standard is therefore to request a license. Again, perfectly clear, it is all in the context of disputes about, not compromising disputes about validity. And then if you go to 3188, MS 3661, you see at 3.21 that ETSI doesn't perform any check on the status and validity of any essential IPRs. And then dispute resolution at 3663 of the MS and 3190 of the document reference. Well,
what was that page?
The page I gave you was MS page 3663, and
Hard copy page.
sorry, the middle number is 3190.
Thank you very much.
You'll see that in respect of dispute resolution, they say that ETSI members should attempt to resolve disputes relating to the application of the policy bilaterally. If it doesn't work, there's a mediation service, but However, it should be noticed that once an IPR patent has been granted, in the absence of an agreement between the parties involved, the national courts of law have the sole authority to resolve IPR disputes. Now, in my submission, it is obvious that ETSI and its members, when drafting this, did so against the background of full knowledge that very often parties dispute validity of patents. And where that is done, that is something that has to go to national courts. In other words, the simple point is that ETSI has been brought into being against the background of territorial patents and the reality that parties, where there are disputes, have to resolve those disputes in national courts. That all that ETSI is doing by the undertaking is ensuring that in such national jurisdictions, the patent owner will not be able to gain injunctive relief to hold up, and the national court, therefore ETSI, against that background, would simply be concerned with the national rights that can be ventilated in that court. So in our submission, there is nothing in ETSI to suggest that the industry was intending to override the normal course of intellectual property litigation. In our submission, the ETSI licensing undertaking doesn't add to the monetary compensation patent owners are entitled to under national law. At national law, they can only obtain monetary compensation if they show infringement of the patents, and the ETSI arrangements were not intended to relieve them of the need to show infringement or to add either monetary compensation or power to the patent owners. So, the fallacy in the respondent's approach is the suggestion that Huawei are free riding on their inventions and not paying for patents they use abroad. But those submissions fail to grapple with the point that the English court is not the court to determine those issues. And the respondent's case gives the ETSI licensing undertaking, we would suggest, an unnatural and absurd meaning, in that it would firstly enable portfolio patent owners to dispense with and avoid scrutiny of the validity of key patents relevant to their commercial dispute with the implementers, such as those of the country of manufacture or principal place of sale, by suing in another country of peripheral significance to the dispute. And one has to remember that on both the respondent's case and the approach that the courts below have adopted, providing you can establish a SEP anywhere over the world, then you could go to that court and get that court to determine the royalty rates for all sorts of other jurisdictions, and to determine that on the basis that patents were valid even though it hadn't investigated that and couldn't do. And in our submission, the effect of this is to deprive the ETSI undertaking of the purpose it was intended to have, which was to avoid the risk that investment in the implementation of standards could be wasted as a result of an essential patent being unavailable. That's clause 3.1 of the policy. And the result that's being put forward here is that terms of access to the standards in any given country are either, if you adopt Mr. Justice Burse and the Court of Appeals approach, made to depend on surrendering what may well be good objections to liability to pay worldwide royalties, or, even if one changes the nature of the license, requires you to pay up front for disputed rights on a basis which is maybe contrary to what the courts in the appropriate state would say. But even if one adjusts all of that, it's requiring you to pay up front when, in our submission, the court, the English court, has no proper basis for doing that. Now, my lords, when you look at ETSI, one of the things that I would also draw to your attention is that ETSI did not seek to set up an international tribunal to determine these matters. It could have done that. I'm not saying there wouldn't be good sense, potentially, in having an international tribunal, but that would require international agreement. And as I said earlier, there have been attempts to set up a European patent court, and so far these attempts haven't reached fruition. But the more important thing is ETSI has not. Now, ETSI, if we go back to Appendix Part 9 and to tab 109, where you have the previous ETSI policy. Yes, sorry, the page number, it starts at 35313058, and the relevant part is at 3583 or 3110, and what ETSI in 1993 had was a rather odd arbitration provision, which was there for a year and then dropped out. The reason I say it was rather odd is that it provided, it's 3583.19, it provided for arbitration of disputes, but what it also decided was that issues of infringement and validity should not be subject to the arbitration, and that's 3584 or 3111 in the middle of the page, 19.9. So, but that, in any event, dropped out of the picture, and most unclear how it was intended to operate. But what all you can extract from it in my submission, but an important point to extract, is that the framers of ETSI originally had in mind that it would be a good idea if you could have a dispute resolution mechanism. But even when they put forward arbitration, they recognized that validity and essentiality could not be subject to it. And of course, one of the reasons why you couldn't have, obviously, validity subject to arbitration is whether a patent is valid or not is a matter of public interest and a matter that needs to be determined by the courts, because otherwise, I mean, for instance, if you had a private arbitration where the arbitrator said this patent is invalid, it wouldn't be much use to the public that apparently there was still the grant of an injunction, of a patent, of a monopoly. So, but the important thing, as I say, that one extracts from it is that ETSI obviously thought about these points, but when it comes to the following year, which is then in force forevermore, they didn't attempt to do that, and they expressly draw attention to the fact that disputes are matters for national courts. Can I just then make a further point, which goes back to this point, which the courts below in Unwired Planet seem to think that all these problems, and same in Conversant, can be sorted out by having some sort of mechanism in the license, even though that's not in Mr. Justice Burse's license, and it's not in the license that Conversant seek. But I want to just address why putting in some mechanism, whilst it sounds an attractive idea, is just superficially attractive. Now, firstly, in purely mechanical terms, you'd have to have a prospective adjustment both going forwards and backwards, and you'd have to have security for to ensure that the money came back. So just stopping there for a moment, one wonders what on earth would be the point of the exercise. But leaving aside that, the prior question is on what principle this court could do this. On what principle can one have a regime of effectively provisional measures in advance of adjudication of liability in a court which is not the court of adjudication, a court of competent jurisdiction to adjudicate liability? Now, there's nothing in ETSI that supports this, and the point that's been overlooked by the courts below is that what they are doing here is providing a final injunction to exclude someone from the UK market unless they entered into a license on terms which firstly necessarily assumes that the foreign patents were valid and essential to the extent provided for by the payment terms, even though they may not be valid and essential, and secondly at rates which might be inconsistent with those set in due course by a foreign court. Now, in our submission, because they fail to really reflect on this, they haven't considered on what basis they would do it, or they could properly do it. Royalties which the English court cannot award as damages, the royalties can't be awarded as damages for foreign patent infringement because they're not justiciable. Can't be directed as provisional payment on account of potential foreign patent infringement either. Probably not popular in this court to raise the rules of court, but CPR 25(1)K only provides power to order an interim payment on account of any damages, debt, or other sum which the court may hold a defendant to pay. That could not apply to foreign royalties in question, because they're not justiciable, and they couldn't be ordered in any event, because the court hasn't found that such royalties are payable, nor could it. So the contractual mechanism which is being discussed in the judgments below, even if suitable arrangements could be devised, is in our submission contrary to principle, and the true position is that a contention that a global patent license, including foreign patents of disputed validity, is appropriate is not, because once validity is an issue, the foreign patents are not justiciable. So the practical effect of this is where matters are in dispute, this court should follow the same approach as the United States, which is it confines itself to the patents in issue. Now, of course, the result of this is that the London court is actually unlikely to play the centre stage that it has currently sought to occupy. But the reason that the London court will not be occupying centre stage is, whether we like it or not, that this country is not likely to be the main source of manufacture of mobile phones, nor is it simply because of our size one of the main markets. Hence, you see a small proportion of Huawei's sales here. So, my lords, I've covered my submissions on Etsy, and I've also, I think, largely covered my submission as to the non-justiciable nature of foreign patents.
But just before you move on, I was taken by your submission that Etsy wasn't intended to give money or power to a patentee beyond what he can get where there is a dispute in the national courts. It seems to me that if you put that together with your submission, that in practice the license, the patents to which an Etsy compliant license in a dispute situation could only properly relate are the ones about which an injunction is being threatened, which I think is your submission. What the undertaking and the Etsy regime really does, doesn't it, is simply to substitute the power of a national court ever to grant an injunction for a power to grant damages in lieu of an injunction.
Exactly. That's
Well, if that's what it was designed to do, one's tempted to ask, why didn't it just say so?
well, what it says is you're entitled to. It is intended to preclude you getting a national injunction, and the price of that is that providing the other side are prepared to pay a FRAND license. And as you saw in the United States decision, there may be circumstances in which you would still get an injunction because, for instance, the implementer was seeking to avoid paying you. So simply saying because damages are an adequate remedy, if you simply said that, you would actually then say, well, because damages are an adequate remedy, you can't get an injunction. Whereas it's not saying you can never get an injunction. That was the point that was made by the court in... what? Yeah, I can't remember. I think it was in the Apple case, Apple or Panopticon. It preserves your right to get an injunction, but it mitigates it or restricts it to a situation where somebody is prepared to pay you the FRAND royalty. But what it doesn't do, my lord, what you can't get out of Etsy, is an intention to expand your rights to get paid anything other than your royalty in respect of the patents in suit. And although I think, to some extent, a reaction to this is to say, well, it's totally ridiculous that it's patent by patent. But the answer is that's where Etsy starts. It's then through the court's case management that you will be able to look at the entire UK position, because the English court or the French court, whatever it is able to look at, if that's what somebody seeks, the entire, all of the sets they have in that jurisdiction. So you get paid for those because you're entitled to pray and aid the national injunctive power in respect of it. And so can I go back before we rise this evening? Could I ask you to go back to the Court of Appeal's judgment in the Unwired Planet case? We spent some time this morning looking at paragraph 58 and 111. Lordship already has understands my submission, of course, Lordship and Ladyship, that paragraphs that these paragraphs are assuming that there is something to which the SEP owner is entitled. But, and I won't repeat that, but a point I would like to make by reference to paragraph 111. Last sentence you see expressly in terms, they talk about the royalties to which Unwired Planet is entitled. A bit further up, they say that unlike a normal patent action, where an unsuccessful defendant faces the prospect of an injunction, the reluctant licensee would know that on the assumption it could only be required to take licenses country by country, there would be no prospect of any effective injunction relief being granted against it, provided it agreed to pay the royalties in respect of activities in any particular country once those activities had been found to infringe. But the flaws in the reasoning in my submission are that an injunction restraining UK patent infringement should serve to protect the UK patent and the UK royalty, which alone is recoverable for its infringement. But the point goes further, because where they talk about effective injunctive relief, the injunction would actually be ineffective to the extent that it provided that there should be recovery even if there was no entitlement under local law, even if it was done on a pro tem basis. And the way the court below has approached it is the injunction has precisely that effect, but that effect would be, in our submission, obviously a wrong one. Now, the suggestion that it is unreasonable for patent, for suggestion it's, I see the time, unless if your lordship's happy to go on otherwise.
Well, if you're about to finish a point, then...
Well, the point I'm about to make will probably take more than 30 seconds.
Well, in that case...
and I'm happy to go on, but
no,
equally I recognise you may have heard more than enough.
Well, we'll adjourn now and sit again at 10:30 tomorrow. Thank you. Can I just ask, are we making reasonable progress?
I am a long way behind where I wanted to be, in that I have agreed with Mr. Block that he would have from 11:30 tomorrow.
Yes.
And I don't know whether he still wants that.
Yes.
I may not be able to address all of the points, but I will seek to.
Well, we will try to restrain ourselves.
No, I welcome interventions. They're extremely helpful.